Hello our dear viewers, you are watching the special TV marathon United Country, and my name is Yaroslav Fedorenko and we are in the national television company in Kiev, Ukraine. So you can see us on the First Ukraine, also on website first.ua.com, and other frequencies you can see on your screen. And we are continuing to speak about the situation in Ukraine, and I want to introduce you our new guests. They are new law experts, Alexey Bежевец and Serhiy Ignatovsky. For the beginning, I want you to explain for our viewers about the defenses of lawyers in Ukraine, because we have last very high example about Denis Buhay, and can you explain for our viewers what happened and what the result we have now?
Okay. Well, actually, a little bit more than months ago, we had a conference here in Kiev. We organized it with our colleagues from Europe, from lawyers from Europe. And during that conference, we shared many cases, many information about violation of attorney's rights during processes, more specifically engaging all those events that took place those days. I mean, protesters and so on. And actually, it was quite common situation when, for attorney, it was quite difficult to defend their clients when the clients were interrogated, arrested, detained, imprisoned, and so on. As we know, attorneys have quite specific rights because they are special persons. They have powers established by law to defend their clients. That's why all those rights should be followed. And actually there were so many cases when police forces, prosecutors' offices, courts, they didn't follow all those requirements of the law, injuring barristers, not following quite specific procedural requirements, trying to identify the attorneys with their clients, and even there were quite a number of cases when barristers were injured. So actually now we see that the whole system, I mean the police system, the prosecutor's office system, they didn't change a lot during this time, and now we see quite a big cases when our colleagues are being imprisoned, are being identified with their clients, and with many violations of specific rights that should be followed. And this case that you mentioned, our colleague Denis Buhay, is one of the cases. Actually, me and my colleague, we were supporters in the group of supporters. We are trying to at least monitor what's going on. And we saw and we can witness that there were quite a number of quite serious violations of attorney's rights. I mean, attorney who were trying to protect Denis Buhay in this procedure. And as well, we should mention that during Denis' arrest, during court hearing, during his detention, imprisonment, now he is being imprisoned for 2 months, so it was a preliminary measure. There were a number of violations. I think we are not going here to go into the details, because it's quite comprehensive legal analysis is required, and the group of attorneys who are protecting him are now working on that. As far as I know, the appeal was filed already. However, we should stress here that we understand that the whole system cannot change the approach in days. Maybe we need months. But anyway, this is a very important point to provide attorneys with the rights that are particularly set forth by law to protect people. Otherwise, if they are in a position where they should defend themselves, not even defend their client, but defend themselves. It makes the ordinary people in a position when they are not defended at all from all those allegedly illegal efforts of some authorities or some specific officers maybe who are trying to arrest them and to involve them in some cases, criminal cases and so on. Maybe my colleague will add something.
Okay, so the main problem of this case and general profession, the attorney profession in Ukraine, is unrespect by the state bodies, by the state law enforcement bodies such as General Prosecutor's Office or Prosecutor's Office, police, the rights of the attorney. Say when Denis was detained, the Council of Attorneys, Kiev Council of Attorneys, should be notified about this. And the General Prosecutor's Office, they didn't notify. Moreover, they have falsified the protocol of this detention, and they have included information that the representative of Kiev Attorney Council was notified, not only notified, but was present when the actual detention took place. So this means that general approach of the system to the attorney profession is not corresponding to the general principles accepted in the worldwide, meaning that the confidentiality of attorney-client relations is not followed in Ukraine. Very often we can see tryings of law enforcement bodies to get into this confidentiality. The rights of the attorney to be not detained or imprisoned without a council of attorneys and with some special procedures are not also followed in Ukraine. Plus, the general approach of executing of this, say, detention or preliminary imprisoning procedure in Ukraine is still such undemocratic. So we can see that trying of, in each case, prosecutor's office or police are trying to put somebody into the jail without any legal grounds to that. These grounds to put somebody in the jail as a preliminary imprisoning for the period of investigation is strictly limited by the criminal procedural code, and these limits are not followed as well. So, plus all these procedural things, when somebody has been detained, this person must be delivered to the court during 60 hours. So in the case with Denis Bugay and many other cases, we can see that people are they're holding somebody in the jail, actually, without providing any right for the legal protection and for the court. They're not bringing person to the court to court decide whether person shall be imprisoned or not. So this we can see in Denis Bugay case. And democratic revolution in Ukraine, unfortunately, it didn't change the system in one day, and the system is still working, and the repressive system, not as a law enforcement body, but as the kind of measure or whatever instrument to influence the people in criminal investigations.
Okay, and how we can defend the lawyers by legislative level? What we can change, or maybe does it enough in our legislative system?
Well, actually, the new wording of the law on attorneys and attorneys' rights was just adopted in 2013. There were quite a number of changes. However, we see that there is still a room for further improvement. Because some rights are still declarative. For instance, as Sergei already mentioned, the representative of Council of Attorneys should be present when an attorney is interrogated. Or in his office, for instance, the police forces are going to make a search for some evidences whatsoever. However, we see that maybe in half of all the cases, this rule is not complied with, just because there is no any punishment for all those officers that do not follow this requirement. It's still declarative. And actually the judges at the end of the day says, okay, there were some discrepancies during the process, but at the end of the day we have the case, so maybe it's not so serious violation of law. And even prosecutors' office representatives sometimes are saying that, okay, this is your law, this is attorney's law, we are prosecutors, we should do our work, so we'll go our way. So I'm absolutely sure that maybe not today, maybe not even tomorrow, but hopefully by the end of the year, the Advocacy Society should elaborate some changes to the law to be adopted to improve that.
Mm-hmm. And do you want something?
Yeah, I mean, frankly speaking, Ukrainian law provides for a number of instruments, and I will say enough of possibilities to protect not even attorney but general citizen in the court. But the problem is how this law is implemented and used by the state state law enforcement services. And we can see, again, I will repeat that they are not even respect the law. So they're trying to breach the law all the time and push the people to the jail without having any evidences of their guiltiness.
Okay, and if we speak about the legislative part, about the confidence, to return the confidence to the judges, we know that there are a lot of the laws, there are new project of laws. How do you think, what can be changed in this system?
So, as far as the draft law, there are several drafts of the law. Is still not adopted. It's hard to say how the procedure will be looking and how it is going to be implemented in general life. But the main problem in Ukrainian society now is the absence of the trust to the court. I mean, we don't trust, people don't trust to the courts. People do not respect courts because previous years of independency did not bring transparency and respect from the society to the courts. And many judges, they are personally identified with such a court system which breaches the people's right. And what we can say is that procedure of lustration is necessary to be approved, and it must happen in Ukraine. But again, we have to, the Parliament and the Ministry of Justice and people involved in this preparation of this draft of the law, of these drafts, must be very careful to do not actually break the system, because Ukrainian court system is full of honest people and honest judges which are performing their duties in accordance with the law. So it must be not a kind of prosecution or whatever of judges. It must be very careful procedure which will be objective and transparent. That's what I can say.
Okay, and there are new other ideas about the citizenship, who can choose the judges. And how do you think, will it be better for a judge system in Ukraine, where citizenship can choose the judges? And, for example, if we make a jury in a judge system in Ukraine?
Actually, if you're meaning the election of judges, which is right, so this idea is always on board in Ukraine, because this is another way to appoint the judge. But again, we have the different kind of courts in Ukraine: administrative, business courts, and common courts. And this system, election of judges, is more, I would say, appropriate to the common courts, where all these deep disputes between people are decided, or criminal cases. But this procedure is more, again, common for the English law system, and is not oftenly used in Napoleonic code system, I would say. And that's why I think it's not the time for Ukraine, because there are many professionals working in appointed, and differences between different kind of courts in Ukraine, I don't think that they will allow at the moment, at this historical moment, to come back to this system or to change to this system.
I would add here that as soon as we have political will, we can actually arrange the whole system and make it transparent and functioning properly. So judges, first of all, must be independent. It's not so, in my opinion, not so difficult to achieve through legal measures, through law. They must be well paid to be independent without any even signs of to be corrupted. It's not so easy to achieve, especially these days in Ukraine. You know, the whole economic situation is not quite good, at least. And third step and third very important thing, there must be a control mechanism of evaluation and re-evaluation of their decisions, their words. So the Supreme Court should have power to be involved in this procedure and be the very last instance to re-evaluate the court decisions. So it could be done, I think, all these three steps quite quickly. However, first of all, there must be political will, and surely, as I already mentioned, the whole system requires financing, which is not easy these days.
Yeah, it's a big problem. And how do you think, as for you, to using the practice of other countries, for example, in different countries, it's a good example about the election of judges, and what other situations or some other examples from other countries judge system we can use in Ukraine?
That's quite a question, because you know, we cannot say that we are very specific, that we're something absolutely different from other countries in the world. On the other hand, we have our own history, and we cannot, you know, change the direction of this big ship named Ukraine in the months to quite different direction. There were already some attempts to change the system. There were the drafts of law about the jury and so on. Yeah. As you see now, they are not adopted because some people think that the society is not ready for that. Some people think that the system is not ready to accept this approach. As Sergei already mentioned, maybe it's, in my opinion as well, maybe it's appropriate in some criminal cases and general cases, but on the other hand, it's almost, I think, not appropriate in administrative cases, in business law cases, and so on. We'll see.
So what I can add, any good practice from any country which provides for the independence of judges, protection of judges, their transparency of courts is acceptable and must be used in Ukraine to adopt the new legislation and new rules of the court system and relationships between courts and the society. So what we need is to make judges independent absolutely in their decisions and making awards. And I think any example which is used in any country in the world is good for that.
And what's about the rights of advocates? How do you think in future in Ukraine will be more advocates or less advocates? How this new laws, for example, can change the system?
Actually, there is such a big number of attorneys these days in Ukraine, even with bar license. However, not all of them are actually practicing the law. Many of them are doing something else but not practicing the law. And actually, some recent steps are being taken to change the situation. Some new requirements have been already adopted for bar exams, how to allow people to be professional, to be a barrister. And I think the number of attorneys should be less in Ukraine. However, the quality of these people should be much higher. And the recent approach, I think, is quite in the proper direction. What do you think?
Right, and so I will agree with you, and I will add that the number of attorneys or whatever, advocates or lawyers in Ukraine is not the issue by itself. So the client makes a choice, and many of attorneys and lawyers, they're not actually working as professionals because they can find their place in the surroundings, so in the society. And I will say that the market, the society, will regulate this issue as well as the legislative regulations of the attorney profession.
Okay, and we have two types of advocates in Ukraine. It's private advocates and government advocates, for example. And
are they?
No.
Because in our judge system, the people who need some defense, they can, the government can give.
You mean
advocates.
free advocates?
Free advocates,
right.
yeah,
Mm-hmm.
like free. But people almost go to the private advocates. So can we say that we don't need this free advocates system or not?
I will say that
change?
Providing of the person who will protect a citizen, a human, in the criminal process is the fundamental principle of legislative system in Ukraine and of the General Declaration of Human Rights. So, if you are requiring the attorney or advocate, you must be provided with this, and the actual existence of the free legal aid that must be provided by the state, if required by the client, by the the person who's under suspicion or whatever, must be followed. I mean, the other thing is the quality of these services, and I will say sometime dependency of such lawyers and advocates from the state. This issue must be regulated, but the fundamental principle must be followed.
Well, as far as I know, these institutes of free of charge attorneys are provided by government to those people who are not able to pay for paid advocates. This institute becomes more and more powerful because there were signs it showed itself as a quite efficient one, because so many people these days cannot, and it's true, you cannot pay for barristers, but by the law those people should be provided by barrister. And there's a question mark where those officers, police officers, prosecutors officers could get those barristers. And actually this institute was implemented not so long ago. From the state budget there were financing to those advocates, and now the institute is functioning and becomes more and more popular, because now those barristers who are in the list of the barristers who can be asked for this as free of charge assistance, free of charge for clients, but not free of charge for them, because they do charge the government for this work. So the list is completed, and actually those people are working and performing their duties in a proper way. However, we should distinguish, because these people are doing their job actually for government. No, they are being paid for government, they are defending their clients. However, if ordinary people can pay for barrister, if they says to police officers, to judge that, okay, I'm gonna have my own barrister in the process, surely it's his or her right, and he or her will do that. Only in case when it's poor people, okay, then the government is providing them with this assistance.
Okay, and as you say about the financial part of problems maybe in the judge system, what other problems can you say in this system?
Well, we may share views here. In my opinion, first of all, the judges, especially during recent years, they were not independent. So the process, how they were appointed, the possibility to influence on their activities, on their awards, it became like a commonly known thing in Ukraine. And surely, as soon as we change the situation and make those judges independent without any possibility to influence on their decisions, their activities illegally, because judge must be absolutely independent in his decision. As soon as we got to that point, we will have quite a new system. And it's very fundamental, because you cannot build a society without properly functioning court system, because you may have all other beautiful decisions, all other offices, governmental authorities, private companies, and so on. But at the end of the day, the judge is ruling what's right and what's wrong. And if this ruling is wrong, initially wrong, the whole system is not functioning. And that's exactly what we had a few months ago in Ukraine.
Yeah, so just to add a few words, I mean, independence is the core principle of the I would say, all this system of courts in any country. And if we're not somehow providing this independence to the court, we are threatening all the country with unlawful decisions, and so we can stay in the position when we are if we are not change. We are not going to change. As an example, the recent thing in the criminal process, a colleague of mine, he has seen the witness that came to the prosecutor during the court trial and to ask some questions. I mean, they were just speaking not loudly, you know. And then the witness came back and was giving some witnesses, and the judge did not react on this. So how can we just name this process? I don't know, but I mean, this is the example of what's going on sometimes in the Ukrainian courts.
Yeah. And for the end, I want to ask you to say what judge system you see tomorrow in the future in Ukraine.
Well, let me start then.
Can be some changes.
Yeah. Independent, very well qualified, honorable people, well-paid people who do perform their duties with all the required facilities for performance of those duties. By the way, because we know that some courts are now in very poor stage. Those people are working in awful environment. With transparent system of appointment, evaluation, reevaluation of their awards, and maybe realize something.
Yeah, and all that, the possibility of the society of Ukrainian people finally to influence and to make something to punish the judge that is performing unlawfully and breaching the law. That's it.
Okay, thank you for your activity.
You're welcome.
So it was the special TV Marathon United Countries, and we speak about the judge system in Ukraine, and we speak with law experts Alexey Bежевец and Sergei Ignatovsky. So my name is Yaroslav Fedorenko, and you can see us on the First Ukraine TV channel, also on website firstua.com, and other frequencies you can see on your screen. So see you, stay with us.